Good morning, Tea Sippers.
I'd like to renew my motion forthwith. I think that the court has heard the motion that we did at the end of the state's case. That motion.
I delayed the process because there was
That shows
some motions,
abundance of.
and then they went on hold for a while,
Failed to meet its burden of proof.
for over an hour. Well, and so that was the reason for the delay.
Innocence for generic opinion. Based on that, I would ask that this court would consider my motion forthwith. Mr. Stanley. On behalf of Demetrius Haley, we renew the motion for judgment acquittal pursuant to Rule 29, incorporate the arguments made at the state of the closed group as before, take this case from the jury. Rarely done. The rules there for a reason. The court has the authority, and this is the appropriate case.
I adopt what Mr. Perry and Mr. Stingle just said regarding Rule 29, the rarity of it, and the fact that you've now heard extensive proof from the defense, who had no burden of proof of any sort. But when you couple that with character witnesses, the undisputed, unrefuted, uncontradicted character witnesses, and what the law is in Tennessee regarding the strengthening of presumption of innocence, measured against the standard of can a reasonable juror find beyond reasonable doubt to a moral certainty that Justice Smith committed any of these crimes, I would say, just as Mr. Stingle said, this is the right case for Rule 29, judgment acquittal. In order, if nothing else, for purposes of justice, Tennessee law, and at the same time, that's what the 13th juror does. It avoids the idea of the jury getting back there and being misled, confused, compromised verdicts, something that is not reliable. Your Honor's been here for this entire trial, and it's heard all the proof, and I would ask that you grant Justice Smith's motion for acquittal.
Stated response.
Your Honor, for the same reasons as before, we believe we have jury questions. I understand the defense has arguments and things, but we have jury questions properly for the jury, and we believe it should go to the jury on all counts.
Listening to the motions that have been presented by the defense in this matter and incorporating the reasoning that the court had previously gave, the court does acknowledge that the state has, or the defense has presented proof and as far.
That tricky something
wow.
but Fox News is claiming President Trump is declining in the polls. President Trump responded and says Fox
Proof that had previously represented from looking at the evidence that was presented thus far in this case. The court believes that there is sufficient proof with regard to Mr. Kadarius being Demetrius Haley and Justice Smith to allow the jury to take this matter for their consideration, having looked at the evidence in the light most favorable to the state as required by law. So the court will deny the motions at this time and we will proceed with the charging of the jury. With regard to the jury instructions, defense, do you all have any proposed instructions to include present argument?
Your Honor, I submitted an instruction regarding blank, and I stand on the submission that has been made. I have let the language catered. I know it's a unique motion, and I know that this is a different case. Normally, that flight instruction goes towards the guilt of the defendant. In this particular case, the flight instruction goes to the presence of mind in the mind of the alleged victim and the motivation to have put up the type of struggle that he did in this case. And it also goes towards the fact that, number one, those sworn officers had a duty to try to apprehend this fleeing suspect. Number two, that they had a duty that did not cease until the alleged victim put his hands in handcuffs and submitted to the handcuffing and allowed the officers to.
It's going to be really, really intense today, y'all.
That, I believe that the instruction regarding flight in a case where we are asserting, I think that the proof bears out that he fled on 3 different occasions. Number one, from the blue lights at 385 in Riverdale. Number two, on the first scene in Walton Rains. And number three, from the eye contact that was made between and the temple have a conversation with Darius Bean, who was making communication based off of the description issued in the photo. Based on those things, we think that we're entitled to that flight instruction.
Judge, Mr. Haley joins in the request for that instruction. Adopts everything Mr. Perry said on behalf of Mr. Dean. And I was just add briefly that it's very important that the officers are responding to resistance as trained. And the presence of the psilocybin mushroom, presence of the stolen ID, the presence of the stolen credit cards and debit cards, can be in the mind of Tyre Nichols when he flees on those 3 occasions. That is something that is appropriate to consider, and it is a factor that the jury should be able to consider in determining Mr. Nichols' state of mind, his actions, and the propriety of these defendants, Mr. Haley specifically, the propriety of the force that he used on the use of force.
I would join in what Mr. Perry and Mr. Siegel said, and I would add that we have video evidence presented to the jury of what Mr. Nichols was doing in 6705 bridge rest, which is part of the flight.
State, you know, response.
For the same reasons that we stated before, we'd ask Your Honor to deny it. Again, this is not a request that the defense be allowed to argue the things that were stated. This is a request for the flight instruction. And the flight instruction is very specific and refers emphasis to being made against the defendant. It is inappropriate in this case.
So listening to the arguments with regard to the inclusion of a flight instruction, the court agrees with the state as far as the court does not and will not deny the defense from their making an argument with regard to what they believe the state of mind was and what the actions required of the officers that night. But with regard to the flight instruction, which is included in the Tennessee Pattern Jury Instruction 42.18, that specific instruction which reads, the flight of a person accused of a crime other than evading arrest is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt the defendant fled is a question for your determination. It goes on to say that if flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of a crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact that flight, if flight is so proven, together with all the other evidence, when you decide the guilt or innocence of the defendant. This instruction specifically is in regard to the defendant and the actions of the defendant and the inference of guilt based off of the potential flight. And so the court will deny the request of a flight instruction and allow that to be argued by the attorney. Any additional instructions?
Your Honor, on behalf of Demetrius Haley, I have filed the written proposed defense theory. I will, as soon as I get a chance, put it in case caption and especially submitted it and file that for the record. But what I had submitted by email has been filed with the court. I would ask that it be included as Demetrius Haley's theory of contention. The state has a theory of contention. It's the indictment. It's been read, and it will be in the jury room. This is Demetrius Haley contests the indictment, has introduced evidence, and this submitted instruction is his theory and contention. I believe that the Tennessee Court of Criminal Appeals in State v. Cozart, citing State v. Phipps, which have been furnished, they say that the
Yeah, please hit the like button.
has every issue of fact raised by the evidence
Coming in.
and material to his defense submitted through proper instructions to the jury as well as, upon request, an instruction which outlines the defense theory of his case. While it is not, it is that authority that I suggest that this is appropriate. While it is not binding authority, in Phipps, the Tennessee Court of Criminal Appeals went to other jurisdictions to look for persuasive authority because there was what they considered a dearth of Tennessee case law. In that case, that was the diminished capacity case that I submitted. So I'm submitting also the Sixth Circuit case, United States versus Garner, cited on the instruction, and the language in it, the Sixth Circuit says, it is our opinion that the trial judge should have presented the defendant, Lorraine Brown's, theory of the case in his instructions to the jury. In a criminal case, it is reversible error for a trial judge to refuse to present adequately a defendant's theory of defense. The trial judge was not required to adopt the language suggested by a defendant in the court's instructions. However, when a theory of defense finds some support in the evidence and in the law, a defendant is entitled to have some mention of that theory in the instructions, even when the supporting evidence is weak or of doubtful credibility. Its presence requires an instruction on the theory of defense. I skipped the internal case sites there. Your Honor, there's evidence to support the theory that Mr. Haley has submitted. What has been submitted is not argumentative. It is simply a statement of facts in evidence that tend to negate the state's theory of the indictment. And I would request that the instruction proposed and emailed and filed be given.
The theory of defense spoken about in Phipps and in the other cases are instructions on the law. So if the defense is some type of self-defense, then the judge has to instruct the law on self-defense. If the defense is diminished capacity, the judge has to instruct the law on diminished capacity. It wouldn't be fair not to, and that's what those cases stand for. Not for the submission of a factual statement by defendants reporting factually, this is my theory of defense. Rule 30 doesn't contemplate that, and no Tennessee case has proved that.
With regard to the defense theory, looking over the Rule 30 as far and the case law that's been presented, all of the case law that the court has looked at references to inclusion of law with regard to theories that's been presented. The court understands that the defendant is at least stating on purpose of the record that it's not argumentative, but this is the defendant's version of the facts that have been presented, which in essence are argument. So the court, looking at the proposed defense theory, does find it to be argument that should not be included in the jury instructions. Also, that the jury instructions and the law that has been cited was not intended to incorporate such arguments, but that those things to be included in the jury instructions were reference to law that may be in support of the defense theory, and not the defense theory of it of itself. So the court will deny the request to include this proposed instruction. Are there any other proposed instructions?
Nothing to say.
All right, is there are any other matters that we need to address before printing the jury instructions and getting ready to charge the jury?
No, yeah.
All right, so we will go ahead and prepare the jury instructions. We'll prepare to charge the jury. We'll stand in recess while we prepare those instructions. Those instructions are a little bit lengthy, so it may take us a few minutes to get those ready, but we'll stand in recess until the instructions are prepared.
Question recess.
It's Darius Bean, Demetrius. Haley and Justin Smith. For one, these three defendants, Darius Bean, Demetrius Haley, and Justin.
Hey, V Money. Good morning. Oh man, I jumped up in here when they were going on recess. Hey, yeah. And I fast forwarded. I want to catch you when they first start talking. And that like button, oh yeah, ooh. You don't even want to know how many likes. It ain't it ain't even, oh, never mind. Lord, oh. They do you girl wrong.
The presentation of proof in this matter, we have now come to a portion where the court is going to give you the law. In each of your chairs, you have a notebook that has the jury instructions. You are free to mark and make notes as we go along. Unfortunately, the law requires that I read this into the record. It's not to insult your intelligence. I'm sure you all can read it, but the court needs to make a record of the instructions that are being presented to the jury. So we are going to read through these instructions. You are welcome to follow along as you choose. State of Tennessee versus Darius Bean, Demetrius Haley, Justin Smith, indictment number 2300241. These three defendants, Darius Bean, Demetrius Haley, and Justin Smith, are being tried at one time. But it must be remembered by you, the jury, at all times, that even though the defendants are being tried together, they are separate and distinct and must be treated as such by the jury. When the word defendant is used in these instructions, it applies equally to Darius Bean, Demetrius Haley, and Justin Smith, unless otherwise stated. Likewise, whenever the singular of a word is used in these instructions, it may be taken equally to mean the plural. The first count of indictment 2300241 charges the defendants Darius Bean, Demetrius Haley, and Justin Smith with the offense of second-degree murder. Embraced and included are the lesser included offenses of facilitation, second-degree murder, voluntary manslaughter, facilitation, voluntary manslaughter, aggravated assault resulting in death, facilitation, aggravated assault resulting in death, reckless homicide, facilitation of reckless homicide, criminally negligent homicide, and facilitation criminally negligent homicide. The second count charges the defendants Darius Bean, Demetrius Haley, and Justin Smith with the offense of aggravated assault, acting in concert. Embraced and included are the lesser included offenses of attempted aggravated assault, facilitation of aggravated assault, reckless aggravated assault, facilitation, reckless aggravated assault, reckless endangerment, assault, and attempted assault. The third count charges the defendants Darius Bean, Demetrius Haley, and Justin Smith with the offense of aggravated kidnapping with bodily injury. Embraced and included are the lesser included offenses of attempted aggravated kidnapping, facilitation of aggravated kidnapping, kidnapping, attempted kidnapping, facilitation of kidnapping, false imprisonment, and attempted false imprisonment. The fourth count charges the defendants, Tadarius Bean, Demetrius Haley, and Justin Smith, with the offense of aggravated kidnapping with deadly weapon. Embraced and included are the lesser included offenses of attempted aggravated kidnapping, facilitation aggravated kidnapping, false imprisonment, and attempted false imprisonment. The fifth count charges the defendants, Tadarius Bean, Demetrius Haley, and Justin Smith, with the offense of official misconduct, unauthorized exercise of official authority. Embraced and included are the lesser included offenses of attempted official misconduct and facilitation of official misconduct. The sixth count charges the defendant, Tadarius Bean, Demetrius Haley, and Justin Smith, with the offense of official misconduct, refraining from performing a duty. Embraced and included are the lesser included offenses of attempted official misconduct and facilitation of official misconduct. The seventh count charges the defendants, Tadarius Bean, Demetrius Haley, and Justin Smith, with the offense of official oppression. Embraced and included are the lesser included offenses of attempted official oppression and facilitation of official oppression. The law makes it the duty of the court to give in charge to the jury the law relative to the case on trial, and under the law given them by the court, render their verdict with absolute impartiality. The jury are the sole judges of the facts and of the law as it applies to the facts in the case. In making up your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The jury in no case should have any sympathy or prejudice or allow anything but the law and the evidence to have any influence upon them in determining their verdict. They should render their verdict with absolute fairness and impartiality as they think the truth and justice dictate. Every fact and circumstance in the case you may consider in arriving at your verdict. The indictment in this case is the formal written accusation charging the defendants with the crime. It is not evidence against the defendants and does not create any inference of guilt. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks I have made do I mean to indicate any opinion as to the facts or what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you understand the evidence and apply the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. The evidence in this case has been completed, and it is my duty now to instruct you on the law. The law applicable to this case is stated in these instructions along with your preliminary instructions, and it is your duty to consider all of them carefully. The order in which these instructions are given do not indicate their relative importance. You should not single out any one or more to the exclusion of another or others, but should consider each one in light of and in harmony with the others. As previously stated, the defendants have been charged by the state of Tennessee in the indictment with second-degree murder, aggravated assault, acting in concert, aggravated kidnapping, 2 counts, official misconduct, 2 counts, and official oppression. These crimes are defined below, beginning with count 1. The charges, also called counts, are designated by numbers.
From Tina Fey and the creator of Saturday Night Live comes Mean Girls, the hilarious hit Broadway music.
The court will now explain the law applicable in count 1 in the indictment. Second-degree murder of Tyre Nichols. Any person who commits second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, Tyre Nichols. And 2, that the defendant acted knowingly. Here, knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Here, intentionally means that a person acts intentionally when it is a person's conscious objective or desire to cause the death of the alleged victim. The distinction between second-degree murder and voluntary manslaughter is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Facilitation of second-degree murder. Any person who facilitates the offense of second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant knew that another person intended to commit second-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense. And 2. That the defendant furnished substantial assistance to that person in the commission of second-degree murder. And 3. That the defendant furnished such assistance knowingly. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intended and intending mean that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The essential elements necessary to constitute second-degree murder and definitions have been set out on page 4. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant unlawfully killed the alleged victim, Tyre Nichols. And 2. That the defendant acted intentionally or knowingly. And 3. That the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Intentionally and knowingly have previously been set out in these instructions. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which render the mind incapable of cool reflection. Facilitation of voluntary
Now, I
manslaughter.
could see that being in
Any
there
person who facilitates the offense of voluntary manslaughter is
with
guilty of a
Haley.
crime. For you to find a defendant
All
guilty
of
of
them.
this offense, the state
They
must
got
have proven
sprayed
beyond a
in their
reasonable doubt
eyes.
the existence of the following essential elements. 1. That the defendant knew that another person intended to commit a voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense. And 2. That the defendant furnished substantial assistance that the person to that person in the commission of voluntary manslaughter. And 3. That the defendant furnished such assistance knowingly. Knowingly, intended, and intending have previously been defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The essential elements necessary to constitute voluntary manslaughter and the definitions have been set out on page 7. Aggravated assault, act resulting in death. Any person who commits the offense of aggravated assault resulting in death is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant intentionally or knowingly caused bodily injury from Tyre Nichols. And 2. That the act resulted in the death of another. Bodily injury includes cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of function of a bodily member, organ, or mental faculty. Knowingly and intentionally have previously been defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Facilitation of aggravated assault resulting in death. Any person who facilitates the offense of aggravated assault resulting in death is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant knew that another person intended to commit an aggravated assault resulting in death, but did not have the intent to promote or assist the commission of the offense or benefit from the proceeds or results of the offense. And 2,
They failed
the
him.
defendant furnished substantial assistance to that person in commission of the aggravated assault resulting in death. And 3, that the defendant furnished such assistance knowingly. Here, knowingly, intended, and intending have previously been defined in these instructions. The requirement of knowingly is also established if it is shown the defendant acted intentionally. The essential elements necessary to constitute aggravated assault resulting in death and definitions have been set out on page 9. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim, Tyre Nichols. And 2, that the defendant acted recklessly. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Here, intentionally and knowingly have previously been defined in these instructions. Facilitation of reckless homicide. Any person who facilitates the offense of reckless homicide is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit a reckless homicide but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of reckless homicide. And 3, that the defendant furnished such assistance knowingly. Here, knowingly, intended, and intending have previously been defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The essential elements necessary to constitute reckless homicide and definitions have been set out on page 11. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim, Tyre Nichols. And 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. Intentionally, knowing, and recklessly have previously been defined in these instructions. If you find, beyond a reasonable doubt, that a defendant was criminally negligent, you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. The defendant's action need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim, before you can convict the defendant, you must also find beyond a reasonable doubt the act of the victim causing the death was a natural and probable result of the defendant's criminal negligence. Facilitation of the criminally negligent homicide. Any person who facilitates the offense of criminally negligent homicide is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit a criminally negligent homicide, but did not have the intent to promote or assist the commission of the offense or benefit in the proceeds or result of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of criminally negligent homicide. And 3, that the defendant furnished such assistance knowingly. Here, knowingly, intended, and intending have previously been defined in these instructions. The requirement of knowingly is also established if the defendant acted intentionally. The essential elements necessary to constitute criminally negligent homicide and definitions have been set out on page 13. The court will now explain the law applicable to count 2 in the indictment. Aggravated assault, acting in concert. Any person who commits the offense of aggravated assault, acting in concert, is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused bodily injury to Tyre Nichols. And 2, that the act resulted in serious bodily injury to Tyre Nichols. And 3, that the defendant committed the offense while acting in concert with 2 or more other persons. Acting in concert means such conduct that would make one criminally responsible for committing or facilitating the offense. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury, intentionally and knowingly, have previously been set out in these instructions. Criminal attempt, aggravated assault, acting in concert. Any person who attempts to commit aggravated assault acting in concert is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of aggravated assault acting in concert. And 2, that the defendant did some act intending to cause an essential element of the offense to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended and intending mean that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. The essential elements necessary to constitute aggravated assault, acting in concert, and definitions have been set out on page 15. Facilitation of aggravated assault, acting in concert of Tyre Nichols. Any person who facilitates the offense of aggravated assault, acting in concert, is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit an aggravated assault acting in concert, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense. And 2, the defendant furnished substantial assistance to that person in the commission of aggravated assault acting in concert. And 3, that the defendant furnished such assistance knowingly. Here, knowingly, intended, and intending have previously been defined in these instructions. The requirements of knowingly is also established if it is shown that the defendant acted intentionally. The essential elements necessary to constitute aggravated assault acting in concert and definitions have been set out on page 15. Reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to Tyre Nichols. And 2, that the act resulted in serious bodily injury to Tyre Nichols. And 3, that the defendant committed the offense while acting in concert with 2 or more other persons. Here, recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when a person is aware of or consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the accused person's standpoint. The requirement of reckless is also established if it is shown that the defendant acted knowingly or intentionally. Acting in concert, bodily injury, serious bodily injury, knowing and intentionally have previously been defined in these instructions. Facilitation of reckless aggravated assault. Any person who facilitates the offense of reckless aggravated assault is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit a reckless aggravated assault, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or result of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of reckless aggravated assault. And 3, that the defendant furnished such assistance knowingly. Knowingly, intended, and intending have previously been defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The essential elements necessary to constitute reckless aggravated assault and definitions have been set out on page 18. Reckless endangerment. Any person who commits the offense of reckless endangerment is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of serious bodily injury. And 2, that the defendant acted recklessly. For the threat of serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to mere possibility of danger. Before you can convict a defendant, the state must have shown beyond a reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of serious bodily injury. Serious bodily injury and recklessly have previously been defined in these instructions. Assault. Any person who commits an assault upon another is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant caused bodily injury to Tyre Nichols. And 2, that the defendant acted either intentionally, knowingly, or recklessly. Bodily injury, intentionally, knowingly, and recklessly have previously been defined in these instructions. Attempt to commit assault. Any person who attempts to commit assault is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense, assault. And 2, that the defendant did some act intending to cause an essential element of the offense to occur, and at the time believed that the act would cause the element to occur without further action upon the defendant's part. Intended and intending have previously been defined in these instructions. The essential elements necessary to constitute assault and definitions have been set out on page 21. The court will now explain the law applicable to count 3 in the indictment. Aggravated kidnapping with bodily injury. Any person who commits an aggravated kidnapping is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly removed or confined Tyre Nichols unlawfully so as to interfere substantially with his liberty. And 2, that Tyre Nichols suffered bodily injury during the removal or confinement. The following italicized instructions and definitions apply to aggravated kidnapping on page 23 and the lesser included offenses of attempt to commit aggravated kidnapping on page 25, facilitation of aggravated kidnapping on page 26, kidnapping on page 27, attempt to commit kidnapping on page 28, facilitation of kidnapping on page 29. The italicized instructions are no more or no less important than other instructions. Italics are used solely for ease of reference and understanding the elements of the offense and lesser included offenses. A removal or confinement is unlawful if it is accomplished by force, threat, or fraud. Although the law requires no specific period of time of confinement or distance of removal, removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of this offense, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the alleged offenses of second-degree murder as charged in count 1, aggravated assault acting in concert as charged in count 2, official misconduct as charged in counts 5 and 6, and official oppression as charged in count 7. In making this determination, you may consider all the relevant facts and circumstances of the case, including, but not limited to, the following factors. A, the nature and duration of the alleged victim's removal or confinement by the defendant. B, whether the removal or confinement occurred during the commission of separate offense. 3, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense. D, whether the removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so. E, whether the removal or confinement reduced the defendant's risk of detection, although the defendant need not have succeeded in this objective. And F, whether the removal or confinement created a significant posed by the separate offense.
Can y'all please hit the like button?
Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged offense. One of these offenses, you must find the defendant not guilty of aggravated kidnapping or any of its lesser included offenses. Bodily injury and knowingly have previously been set out and defined in these instructions. Attempt to commit aggravated kidnapping. Any person who attempts to commit aggravated kidnapping is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of aggravated kidnapping. And 2, that the defendant did some act intending to cause an essential element of the offense to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended and intending have previously been defined in these instructions. The essential elements necessary to constitute aggravated kidnapping and definitions have been set out on page 23. Facilitation of aggravated kidnapping. Any person who facilitates the offense of aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven.
ThredUp is an online thrift store and consignment store, and they have such high quality pieces that are all.
1, that the defendant knew that another person intended to commit an aggravated kidnapping, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or result of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of aggravated kidnapping. And 3, that the defendant furnished such assistance knowingly. Knowingly, intended, and intending have previously been defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The essential elements necessary to constitute aggravated kidnapping and definitions have been set out on page 23. Kidnapping. Any person who commits the offense of kidnapping is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly removed or confined Tyre Nichols unlawfully so as to interfere substantially with his liberty. And 2, that the removal or confinement was under circumstances that exposed Tyre Nichols to substantial risk of bodily injury. The instructions regarding removal or confinement, as explained above, in the italicized instructions for aggravated kidnapping under this count, count 3, apply to the lesser included offense. Refer to those italicized instructions there. Bodily injury and knowingly have previously been defined in these instructions. Attempt to commit kidnapping. Any person who attempts to commit kidnapping is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense, kidnapping. And 2, that the defendant did some act intended to cause an essential element of the offense to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended and intending have previously been defined in these instructions. The essential elements necessary to constitute kidnapping and definitions have been set out on page 27. Facilitation of kidnapping. Any person who facilitates the offense of kidnapping is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit a kidnapping, but did not have the intent to promote or assist in the commission of the offense or benefit in the proceeds or result of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of kidnapping. And 3, that the defendant furnished such assistance knowingly. Knowingly, intended, and intending previously been defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The essential elements necessary to constitute kidnapping and definitions have been set out on page 27. False imprisonment of Tyre Nichols. Any person who commits the offense of false imprisonment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant removed or confined Tyre Nichols unlawfully so as to interfere substantially with his liberty. And 2, that the defendant acted knowingly. The instructions regarding a removal or confinement, as explained above in the italicized instructions for especially aggravated kidnapping under this count, count 3, apply to this lesser included offense. Refer to those instructions there. Knowingly have previously been defined. Any person who attempts to commit false imprisonment is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of false imprisonment. And 2, that the defendant did some act intending to cause an essential element of the offense to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended and intending have previously been defined in these instructions. The essential elements necessary to constitute false imprisonment and definitions have been set out on page 30. The court will now explain the law applicable to count 4 in the indictment. Aggravated kidnapping of Tyre Nichols with a deadly weapon. Any person who commits an aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly removed or confined Tyre Nichols unlawfully so as to interfere substantially with his liberty. And 2, that the defendant possessed or threatened the use of a deadly weapon. The italicized instructions for aggravated kidnapping under count 3 apply to aggravated kidnapping in this count, count 4, on page 23. Please refer to that page for the definitions and instructions as needed. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury or or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm means any weapon that will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Knowingly has been previously defined for you in these instructions for aggravated assault resulting in death under count 1. refer to the definition there. Attempt to commit aggravated kidnapping. Any person who attempts to commit aggravated kidnapping is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant intended to commit the specific offense, aggravated kidnapping. And 2. That the defendant did some act intending to cause an essential element of the offense to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended and intending have previously been defined in these instructions. The italicized instructions for aggravated kidnapping under count 3 apply to aggravated kidnapping and this count 4, on page 23. Please refer to that page for the definitions and instructions as needed. The essential elements necessary to constitute aggravated kidnapping and definitions have been set out on page 32. Facilitation of aggravated kidnapping. Any person who facilitates the offense of aggravated kidnapping is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. If the defendant knew that another person intended to commit an aggravated kidnapping, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense. And 2. That the defendant furnished substantial assistance to that person in the commission of aggravated kidnapping. And 3. That the defendant furnished such assistance knowingly. Knowingly, intended, and intending have previously been set out, defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The italicized instructions for aggravated kidnapping under count 3 apply to aggravated kidnapping in this count 4, on page 23. Please refer to that page for definitions and instructions as needed. The essential elements necessary to constitute aggravated kidnapping and definitions have been set out on page 32. False imprisonment of Tyre Nichols. Any person who commits the offense of false imprisonment is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1.
If you don't have a legitimate reason to hold somebody, let them go.
Substantially with his liberty. And 2. That the defendant acted knowingly. The instructions regarding a removal or confinement as explained above in the italicized instructions for especially aggravated kidnapping under this count 3, on page 23 apply to this lesser included offense. Refer to those instructions there. Knowingly has previously been defined in these instructions. Any person or attempt to commit false imprisonment. Any person who attempts to commit false imprisonment is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That is, should be number 1. 1. That the defendant intended to commit the specific offense of false imprisonment. And 2. That the defendant did some act intending to cause the essential elements of the offense to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended and intending have previously been defined in these instructions. The essential elements necessary to constitute false imprisonment and definitions have been set out on page 35. The court will now explain the law applicable to count 5 in the indictment. Official misconduct, unauthorized exercise of official power. Any public servant who commits the offense of official misconduct is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1. That the defendant acted as a public servant. And 2. That the defendant committed an act relating to the defendant's office or employment that constituted an unauthorized exercise of official power. And 3. That the defendant acted knowingly or intentionally. And 4. That the defendant acted with the intent to obtain a benefit, or to harm another. Act and acted means a bodily movement, whether voluntary or involuntary, and includes speech. Intent, intentionally, and knowingly have previously been defined in these instructions. Public servant means a person elected, selected, appointed, employed, or otherwise designated as one of the following, even if the public servant has not yet qualified for office or assumed the duties: an officer, employee, or agent of government. Attempt to commit official misconduct. Any person who attempts to commit official misconduct is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of official misconduct. And 2, that the defendant did some act intending to cause an essential element of the offense to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended and intending have previously been defined in these instructions. The essential elements necessary to constitute official misconduct and definitions have been set out on page 37. Facilitation of official misconduct. Any person who facilitates the offense of official misconduct is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit an official misconduct, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of official misconduct. And 3, that the defendant furnished such assistance knowingly. Knowingly, intended, and intending have previously been defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The essential elements necessary to constitute official misconduct and definitions have been set out on page 37. The court will now explain the law applicable to count 6 in the indictment. Official misconduct, refraining from performing a duty. Any public servant who commits the offense
They all
of
did
official
misconduct.
is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant acted as a public servant. And 2, that the defendant refrained from performing a duty that was imposed by law or that was clearly inherent in the nature of the office or employment. And 3, that the defendant acted knowingly or intentionally. And 4, that the defendant acted with the intent to obtain a benefit or to harm another. Acted knowingly and intentionally have previously been defined in these instructions. Attempt to commit official misconduct. Any person who attempts to commit official misconduct is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of official misconduct. And 2, that the defendant did some act intending to cause an essential element of the offense to occur, and at the time believed that the act would cause the element to occur without further action on the defendant's part. Intended and intending have previously been defined in these instructions. The essential elements necessary to constitute official misconduct and definitions have been set out on page 41. Facilitation of official misconduct. Any person who facilitates the offense of official misconduct is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit official misconduct, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of official misconduct. And 3, that the defendant furnished such assistance knowingly. Here, knowingly, intended, and intending have previously been defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The essential elements necessary to constitute official misconduct and definition have been set out on page 41. The court will now explain the law applicable to count 7 in the indictment, official oppression. Any public servant who commits the offense of official oppression is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant was a public servant acting under color of office or employment. And 2, that the defendant intentionally subjected another to mistreatment or to arrest, detention, stop, frisk, halt, search, seizure, or dispossession that the defendant knew was unlawful. Intent, intentionally and knowingly, and public servant have previously been defined in these instructions. The public servant acts under color of office or employment if the servant acts or purports to act in an official capacity or takes advantage of such actual or purported capacity. Attempt to commit official oppression. Any person who attempts to commit official oppression is guilty of a crime. For you to find a person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of official oppression. And 2, that the defendant did some act intending to cause an essential element of the offense to occur, and at the time believed the act would cause the element to occur without further action on the defendant's part. Intended and intending have previously been defined in these instructions. The essential elements necessary to constitute official oppression and definitions have been set out on page 44. Facilitation of official oppression. Any person who facilitates the offense of official oppression is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knew that another person intended to commit an official oppression, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense. And 2, that the defendant furnished substantial assistance to that person in the commission of official oppression. And 3, that the defendant furnished such assistance knowingly. Knowingly, intended, and intending have previously been defined in these instructions. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. The essential elements necessary to constitute official oppression and definitions have been set out on page 44. Considering multiple defendants. You should give separate consideration to each defendant. Each defendant is entitled to have his case decided on the evidence and the law applicable to that particular defendant. Any evidence which was limited to a specific defendant should not be considered by you as to any other defendant. You can acquit all defendants or convict all, or you can acquit one or more and convict one or more. If you cannot agree upon a guilt as to all defendants, but you do agree upon the verdict as to one defendant, you must render a verdict as to the one or the ones upon which you agree. You will receive separate verdict forms on the charged counts and lesser offenses for each defendant. Identity. One of the issues in this case is the identification of the defendant as the person who committed the crime. So the state has the burden of proving identity beyond a reasonable doubt. Identification testimony is an expression of belief or impression by the witness, and its value may depend upon your consideration of several factors. Some of the factors which you may consider are: 1, the witness's capacity and opportunity to observe the offender. This includes, among other things, the length of time available for observation, the distance from which the witness observed, the lighting, and whether the person who committed the crime was a prior acquaintance of the witness. 2, the degree of certainty expressed by the witness regarding the identification and the circumstances under which it was made, including whether it's the product of the witness's own recollection. 3, the occasions, if any, on which the witness failed to make an identification of the defendant or made an identification that was inconsistent with the identification at trial. And 4, the occasions, if any, on which the witness made an identification that was consistent with the identification at trial and circumstances surrounding such identification. 5, any other factors fairly raised by the evidence. Again, the state has the burden of proving every element of the crime charged, and this burden specifically includes the identity of the defendant as the person who committed the crime for which he is on trial. If, after considering the identification testimony in light of all the proof, you have a reasonable doubt that the defendant is the person who committed the crime, you must find the defendant not guilty. Evidence, direct and circumstantial. The guilt of any defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact in issue without inference or presumption. Direct evidence is those parts of testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard what happened firsthand. If witnesses testified about what they themselves saw or heard, they presented direct evidence. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact in issue, but from which that fact may be logically inferred. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all evidence which is not direct evidence. When the evidence is made up entirely of circumstantial evidence, then before you would be justified in finding any defendant guilty, you must find that all the essential facts are consistent with the hypothesis of guilt, as that is to be compared with all the facts proved.
Hey, Scott.
The facts must exclude every other reasonable theory or hypothesis except that of guilt, and the facts must establish such a certainty of guilt of a defendant as to convince the mind beyond a reasonable doubt that the defendant is the one who committed the offense. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. It is not necessary that each particular fact should be proved beyond a reasonable doubt.
Since 1936, Kansas City calls Everett Milberger Pest Control for effective and professional extermination
Necessary to constitute the crime charged. Before a verdict of guilty is justified, the circumstances taken together must be of conclusive nature and tendency, leading on the whole to a satisfactory conclusion and producing in effect a moral certainty that the defendant and no one else committed the offense. Presumption of innocence. You enter upon this investigation with presumption that each of the defendants are not guilty of any crime, and this presumption stands as a witness for them unless it is rebutted and overturned by competent and credible proof. It is, therefore, incumbent upon the state, before you can convict any defendant, to establish to your satisfaction, beyond a reasonable doubt, that the crime charged in this indictment has been committed, that the same was committed within the county of Shelby and the state of Tennessee before the finding of the indictment, and that the defendant or defendants committed the crime in such a manner that would make them guilty under the law here defined and explained to you. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendants are not required to prove their innocence. Reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case, and an inability, after such investigation, to let the mind rest easily upon the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and that certainty is required as to every element of proof needed to constitute the offense. Credibility of witnesses. You are the exclusive judges of the credibility of witnesses and the weight to be given to their testimony. If there are any conflicts in the testimony of different witnesses, you must reconcile those conflicts. if you can, without hastily or rashly concluding that any witness has sworn falsity, for the law presumes that every witness has told the truth. It is your job to decide what the facts are, what the facts of this case are. When you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe, and how important you think the witness's testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules or judging whether you believe a witness, but it may help you to think about these questions. 1. Was the witness able to see and hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? 2. Did the
Blows
witness
to the
seem to have a
head.
good memory? 3. How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions? 4.
Oh,
Has
yeah.
there been any evidence
The wizard.
presented regarding the witness's intelligence, respectability, or reputation for truthfulness? 5. Does the witness have any bias, prejudice, or personal interest in how the case is decided? 6. Did the witness have a motive to testify truthfully or to testify untruthfully? 7. Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? 8. In general, does the witness have any special reason to tell the truth or any special reason to lie? 9. All in all, how reasonable does the witness testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You must think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently. Witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness has deliberately lied about something that is important or to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest.
Can y'all please? I hit the like
Expert
button.
witness. During the trial, you heard Derek Miller, who was described to us as an expert in the field of digital forensic examiner. You also heard the expert testimony of Dr. Marco Ross, who was described to us as an expert in the field of forensic pathology. You also heard the expert testimony of Dr. James Turner, who was described to us as an expert in the field of forensic pathology. You also heard the expert testimony of Ms. Samantha Spencer, who was described to us as an expert in the field of forensic biology through DNA analysis. You also heard the expert testimony of Mr. Jared Zawicki, who was described to us as an expert in the field of defensive tactics, human factors, deadly force, police training, video and digital analysis. You also heard expert testimony of Mr. John Tisdale, who was described to us as an expert in the field of police policy and use of force. You also heard the expert testimony of Mr. Don Cameron, who was described to us as an expert in the field of police training and use of force. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge or experience, may testify and state their opinions concerning such matters and give reasons for their testimonies. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to
Absolutely,
you
we're
to
not.
decide whether you
Not the
believe this
wizards.
testimony and choose to rely upon it. Part of that decision will depend on your judgment whether this witness's training and experience is sufficient for the witness to give the expert opinion that you heard. You must decide whether the witness's opinions were based on sound reason, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Impeaching a witness. A witness may be impeached by proving that the witness made some material statements out of court which are at variance with the witness's evidence on the witness stand. However, proof of prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility, and not as substantive evidence of the truth of the matter asserted in such statements, unless the trial judge has made those statements an exhibit. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard the witness's evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. Criminal responsibility for the conduct of another. A defendant is criminally responsible as a party to second-degree murder, aggravated assault, acting in concert, aggravated kidnapping, official misconduct, and official oppression if the offenses were committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. A defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense or to benefit in the proceeds or result of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Here, intent means that the person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. A person is criminally responsible for an offense committed by the conduct of another if, having a duty imposed by law or voluntarily undertaken to prevent commission of the offense, and acting with the intent to the benefit in the proceeds or result or the results of the offense, or promote or assist its commission. A defendant fails to make a reasonable effort to prevent commission of the offense. Intent means that a person acts intentionally with respect to the nature of conduct or to a result of the conduct when it's the person's conscious objective or desire to engage in the conduct or cause the result. A defendant who is criminally responsible for an offense may be found guilty not only of the offense, but also for any other offense or offenses committed by another if you find beyond a reasonable doubt that the other offense or offenses committed were natural and probable consequences of the original offense for which the defendant is found criminally responsible, and that the elements of the other offenses or offenses that accompanied the original offense have been proven beyond a reasonable doubt. In deciding the criminal responsibility of each defendant, the jury may also take into consideration any evidence offered that a defendant attempted to thwart or withdraw from any of the offenses that followed from the original offense. To find a defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. encouragement of the principal offender is sufficient. However, mere presence during the commission of an offense is not sufficient to support a conviction. Before you can find a defendant guilty of being criminally responsible for said offense or offenses committed by the conduct of another, you must find that all the essential elements of said offenses have been proven by the state beyond a reasonable doubt. Criminal responsibility is not a separate criminal charge of the indicted charge or lesser included offenses. It is an alternate theory of criminal liability by which the state may prove a defendant's guilt based on the conduct of another person. Consequently, there is no separate verdict form for criminal responsibility. You will use the verdict forms for the offenses for which you find a defendant criminally responsible should a defendant be found guilty of any offense under this theory. It is not a defense that a person for whom's conduct the defendant is criminally responsible has not been convicted or was convicted of a different offense or different type or class of offense. Witness claiming to be a participant. The prosecution has presented a witness who claims to have been a participant with the defendants in the crime charge. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in the light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Limiting instruction. Members of the jury, you have received as evidence a memorandum of understanding, which has been marked Exhibit 4, and a guilty plea marked as Exhibit 16 of a charged co-defendant, Desmond Mills. You are instructed that this evidence may be only considered with respect to the guilt or innocence of the co-defendant for whom they belong. In other words, the evidence can only be used to assess whether the co-defendant is guilty or not guilty of the charges against them and cannot make any assumptions or inferences about another defendant in this case. Each defendant must be evaluated on the evidence presented specifically against them. The guilt or innocence of one defendant should not influence by a co-defendant's statements or any actions or statements attributed to them. You should assess the evidence against each defendant independently. Do not allow a co-defendant's statements to influence your judgment or deliberations regarding another defendant in this case. Evidence of good character. Evidence of good character has been offered on behalf of the defendants Tadarius Bean and Justin Smith. This is to be considered by the jury along with all the other evidence in the case to determine if there is a reasonable doubt about the defendant's guilt. A person of good character may violate the law, but a person of good character is less likely to violate the law than one of bad character. If you find the defendant's character to be good, such may be considered for purpose of strengthening his presumption of innocence. If you find the defendant's character to be good, it may stand as a witness on his behalf, and you should consider it along with all the other evidence in determining whether the defendant is guilty or not guilty. Defendants not testifying. The defendants, Tadarius Bean, Demetrius Haley, and Justin Smith, have each not taken the stand to testify as a witness, but you shall place no significance on this fact. Each defendant is presumed innocent, and the burden is on the state to prove the defendant's guilt beyond a reasonable doubt. No defendant is required to take the stand on his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Cause of death. Before a defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant, by the conduct of another for whom the defendant is criminally responsible, or both. The proximate cause of death is that cause which, in a natural and continuous sequence, unbroken by independent intervening cause, produces the death and without which the death would not have occurred. A defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death. In such a case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may have been a proximate cause of the death. However, it is a defense to homicide if the proof shows that the death was caused by an independent intervening act or omission of the deceased or another which a defendant in the exercise of ordinary care could not reasonably have anticipated as likely to happen. However, if in the exercise of ordinary care a defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of death. The sequence of events or the particular injury doesn't need to be foreseeable. It's only necessary that the death falls within the general field of danger which a defendant should have reasonably anticipated. If some other circumstances cause the victim's death unrelated to the defendant's action, that would be a defense to homicide unless the circumstances was the natural result of the defendant's acts. There is evidence in this case that the deceased required medical attention as a result of injuries that may have been unlawfully inflicted by a defendant, and that such treatment itself may have contributed to the death of the deceased. If you find this evidence to be true, then you must determine whether the medical treatment is of such a character as to relieve the defendant of the responsibility for the death. One who unlawfully and seriously injures another to the extent that medical attention is required bears the risk that improper treatment may result in death of the injured person. If a defendant unlawfully and seriously injures the deceased, he is not relieved of responsibility unless the treatment was performed in a grossly negligent and unskillful manner, and unless it was the sole cause of the death. If you find that a defendant's acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt about this proposition, then you must find the defendant not guilty. Jury notes. Members of the jury, the court charges that if any of you have been taking notes in this case, that these notes are for your individual use only, and that you should not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Multiple counts, finding on each required. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your findings as to each crime charge must be stated in your verdict. Unanimous verdict. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Deliberation, order of consideration as to defendant Darius Bean, Demetrius Haley, and Justin Smith. In deciding your verdict for each count, you shall first consider the offense charged in the indictment. If you find the defendant guilty of that offense beyond a reasonable doubt, you should return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in the order from greatest to least within each count of the indictment. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense charged in the indictment. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count of the indictment, you shall return a verdict of not guilty for that count of the indictment. Verdict form, count 1, second-degree murder. We, the jury, find the defendant Darius Bean, only checking one box. First charge for your consideration, the indicted charge, guilty of second-degree murder. The lesser included offenses in the order of consideration, should the jury find the defendant guilty, would be facilitation of second-degree murder, guilty of manslaughter, guilty of facilitation of voluntary manslaughter, guilty of aggravated assault acted resulting in death, guilty of facilitation of aggravated assault resulting in death, guilty of reckless homicide, guilty of facilitation of reckless homicide.
Today, reliability means everything. At Shields, we're by your side. With the Shields Visa, we're here to help you do more of what you love.
Guilty to the indicted charge or any lesser included offenses, the jury is to select not guilty as charged in the first count of the indictment signed by jury foreperson. The same instructions with regard to count 1 with regard to the defendant Demetrius Haley. In the following page, the same instructions with regard to count 1 for the defendant Justin Smith. Verdict form count 2, aggravated assault acting in concert. We, the jury, find the defendant Darius Bean. Again, only check one box. The indicted charge, guilty of aggravated assault acting in concert. The lesser included offenses in order of consideration, guilty of attempted aggravated assault, guilty of facilitation of aggravated assault, guilty of reckless aggravated assault, guilty of facilitation of reckless aggravated assault, guilty of reckless endangerment, guilty of assault, guilty of attempted assault. Should the jury have a reasonable doubt as to all of the indicted charge and the lesser included, the jury is to select not guilty as charged in the second count of the indictment signed by jury foreperson. Same instructions apply on the following page to the defendant Demetrius Haley. On the following page, the same instructions with regard to count 2 for the defendant Justin Smith. Verdict form count 3, aggravated kidnapping with bodily injury. We, the jury, find the defendant Darius Bean. Again, check only one box. The indicted charge, guilty of aggravated kidnapping with bodily injury. The lesser included offenses in order of consideration, guilty of attempted aggravated kidnapping, guilty of facilitation of aggravated kidnapping, guilty of kidnapping, guilty of attempted kidnapping, guilty of facilitation of kidnapping, guilty of false imprisonment, guilty of attempted false imprisonment. Should the jury have a reasonable doubt as to the indicted charge or any of the lesser included offenses, it is to select the not guilty as charged in the third count of the indictment signed by the jury foreperson. The same instructions apply on count 3 with regard to the defendant, Demetrius Haley. On the following page, with regard to count 3, the defendant, Justin Smith, the same instructions apply. With regard to verdict form, count 4, aggravated kidnapping with a deadly weapon, we, the jury, find the defendant only check 1. The indicted charge guilty of aggravated kidnapping with a deadly weapon. The lesser included offenses in order of consideration: guilty of attempted aggravated kidnapping, guilty of facilitation aggravated kidnapping, guilty of false imprisonment, guilty of attempted false imprisonment. Should the jury have a reasonable doubt with regard to the indicted charge or any lesser included offense, it is to select not guilty as charged in the 4th count of the indictment signed by jury foreperson. The same instructions apply on the following page with regard to count 4 and the defendant, Demetrius Haley. On the following page, the same instructions apply to count 4 with regard to the defendant, Justin
Yeah, you know I
Smith.
will.
Verdict form, count 5, official misconduct, unauthorized exercise of official authority. We, the jury, find the defendant, Darius Bean, only check 1 box. The indicted charge be guilty of official misconduct, unauthorized exercise of official authority. Lesser included
Try me
offenses
by
in order of
myself.
consideration
Ooh.
would be
Oh.
guilty of attempted official misconduct, guilty of facilitation of official misconduct. Should the jury have a reasonable doubt as to, with regard to the indicted charge or any of the lesser included offenses, is to select not guilty as charged in the 5th count of the indictment signed by a jury foreperson. The same instructions apply on the following page, verdict form, count 5, with regard to the defendant, Demetrius Haley. Same instructions apply on the following page, verdict form, count 5, with regard to defendant, Justin Smith. Verdict form, count 6, official misconduct, refraining from performing a duty.
How many total counts against them do they have?
Only
Oh.
check 1 box. Indicted charge is guilty of official misconduct. Lesser included offenses in order of consideration would be guilty of attempted official misconduct, guilty of facilitation of official misconduct. Should the jury have a reasonable doubt as to the guilt of the defendant on the indicted charge or any lesser included offenses, it is to select the not guilty as charged in the 6th count of the indictment. On the following page, the same instructions apply to count 6, verdict form, with regard to defendant Demetrius Haley. On the following page, verdict form, count 6, the same instructions apply to defendant Justin Smith.
He looked worried as hell.
Verdict form, count 7, official oppression.
Oh.
We, the jury, find the defendant, Darius Bean, only check 1. Indicted offense, guilty of official oppression.
That hair so thinning right there, ain't it?
Guilty of attempted official oppression, guilty of facilitation of official oppression. Should the jury have a reasonable doubt of the defendant's guilt with regard to the indicted charge or any of the lesser included offenses, the jury is to select not guilty as charged in the 7th count of the indictment signed by the jury foreperson. Verdict form, count 7, the same instructions apply with regard to Demetrius Haley. On the following page, verdict form, count 7, the same instructions apply with regard to defendant Justin Smith. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. If a question arises during the
And them
deliberation,
facts
first go
will
back
not
and
set
review
you
your
free
jury
this
instructions,
time.
as the majority of your answers to the jury questions are found in there. If the question remains and/or you need further instructions, please print your question on a sheet of paper and have the foreperson sign it and give to the deputies. I will read your question and I may call you back into the courtroom to try to help you. But more times than not, the court's answers will be to look back at your jury instructions. Please understand that I may only answer questions about the law cannot answer questions about the evidence. You will write your verdict clearly as to the indictment on the inside of the jacket as instructed on the previous pages, and have one of the names of the unsigned as the verdict on the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and report to the court such verdicts as truth dictates and justice
We
demands.
finna get closing arguments. When
Now,
he,
ladies and
ooh,
gentlemen,
finally.
you've now received the law. You've heard and received all the proof. Yet it's still not time for the deliberation. And we are going to take just a brief recess to allow you all to step out so we don't have any interruptions while we go through the closing arguments. So please make sure you do not discuss the cases. You can leave your notebooks and those binders in your chairs. It's going to take a brief recess.
We're going to do
Whew.
after recess.
Hey, my ass is tender. Ooh. See, yeah. Shit. Hold on, let me fast forward. Are they back
Slow
yet?
it down.
They back, yeah. Hold
And
on.
I'm going to show you some video again. And I ask you to listen to things and watch things
I didn't want to be this close to it, though.
with certain intent, looking for certain things.
Hold
okay?
on.
You've seen it all, but now we kind of have to put the pieces together. And the first
Hold on, y'all.
thing I want you to do, and this is different. This is different than we've done all week.
Hold on. Why is it giving me such a hard time? Oh, they've been back. Let's start here. I don't want to mess with it no more. Let's wait for them to come on back. We know they back. The wait is over. The wait is... Go and get you some water, some tea, whatever. Hit the like button so I won't have to keep doing a whole bunch of stops and goes. Stops and goes. If y'all don't support the platform, I'm waste. Well, cause this takes time and effort, electricity and all of that. Phone use, all that. So hit the like button, or you can hit the Cash App. Cash App, you don't have to worry about hearing my mouth. Yeah. Okay. Okay. Oh, Lord. That's the real deal. Holyfield right there. Ain't that right? Be money. Come on. Come on. Watch when I move it. I'm gonna go too far up.
Tyre had a special relationship with his mom. You heard her talk a little bit about it. I don't know if y'all noticed, in one of the pictures that was introduced as part of the autopsy, he had his mom's name tattooed on his shoulder, rope on. Tyre left that afternoon, and he never made it home for dinner because he came into contact with these officers. And the next time Miss Robine saw her son, he was in the hospital in the wee hours of January 8th, and this is what he looked like.
Oh.
coming in contact with these officers. And he almost made it home. He's so close. There's a map that's been introduced, and it shows you all the locations that we've talked about. Look how close they are. You heard Mr. Yvonne testify that to get to the scene where all this happened, just basically 80 feet from her front door. And at that first stop, that chaotic stop, when there's so much screaming and so much chaos, one of the things you hear Tyre say is, "I'm just trying to go home." He's just trying to get home to his mom's house. But he doesn't make it, because he comes in contact with these officers. One of the things that was said in trial this week, when Officer Mills was testifying, when the defense attorneys asked a question and said, "So Tyre was whipping y'all's tail." I don't know if you remember this. Tyre was whipping y'all's tail. Tyre, the smallest person out there, 5 officers. Tyre was whipping y'all's tail. To show you the pictures that were introduced into evidence of each of those officers at the end of that night. Officer Bean. Officer Emmett Martin. Officer Demetrius. Officer Justin Smith.
Oh.
Officer Desmond Mills.
Mm-mm.
They were getting their tails whipped. This is them that night, after the fact. You see the picture of Tyre again? And about the same time those pictures were taken by TBI, Mr. Rodney Wells, Tyre's stepdad, takes this picture at St. Francis Hospital. So Tyre was whipping their tail? That's what they want you to believe? I know y'all seen a ton of video this week. When you go back to deliberate, you'll have that video. You'll be able to watch any part of it that you want. You'll be able to zoom in. You'll be able to slow it down. And I'm going to show you some video again. I'm going to ask you to listen to things and watch things, but with certain intent, looking for certain things, okay? You've seen it all, but now we kind of have to put the pieces together. And the first thing I want you to do, and this is different than we've done all week. I'm going to play a portion of Bean's body-worn camera. And I'm going to just set it up a bit. Y'all seen it. Bean is the officer who's riding with Officer Mills. Officer Mills testified that he sees someone matching the description in the rear view. They kind of do a U-turn, and then you see Officer Bean jump out of the car and start Tyre. And if y'all remember, as Officer Bean gets to Tyre and tackles him to the ground, shortly thereafter, his body-worn camera, which is worn here on the front of the chest, falls off. So we continue to hear the audio, but the camera is facing down, so it goes flat. But you can hear the audio. And I want you to watch and listen with me in just a few moments to that clip. What I want you to listen for, and we're going to listen to the portion where everything happens to Tyre. We're going to hear those first 2 kicks from Officer Martin, where Bean and Smith are holding down. We're going to hear the punches. And then the final 2 kicks from Haley and Martin. And I say we're going to hear because even though this body cam is on the ground somewhere over here, we don't really know where, some of those impacts you can hear. you can hear the kick making contact. You can hear some of those punches. And keep in mind, that camera is not on his chest. That camera is over on the ground somewhere. And you can hear it. So I want you to listen for that. But more so, what I want you to listen to is Tyre. Because these are some of the last words we hear Tyre say. And the first thing that you'll hear him do, and you've heard it this week, but I want you to listen, really listen, is yell for his mom. And he's yelling for his mom, because he wants his mom, I'm sure, but also, how close is he to home? How close is he to his mom? So listen to that, and then listen to what Tyre sounds like as the video goes on. Moaning, pain, but listen all the way through. And if we can have the lights turned off and we'll play that video. And y'all will remember, you're probably familiar enough by now, but every time a body cam turns on, there's about a minute that goes by that there's no audio. And then after a minute, the audio pops on.
It's cruelty. Some people have more care and humanity for animals than they did for what happened to him that night.
Again, I'm going to focus on Tyre. What we hear Tyre say.
Oh, Lord.
we hear Tyree say, and he says it 3 times right there, and I don't know if y'all can hear it, I know it's hard, there's other noises in here. He says, help me. Help me. 3 times. You know what happens right after that 3rd time he says, help me? Then Haley runs in and kicks him, and then Emmett Martin kicks him again. Those are the last words we hear from Tyree. Help me. And who is supposed to help him? Those guys.
Wow.
They got a duty.
Wow.
A duty to help him. They don't. No one helps them. No witness told you Tyree punched, Tyree kicked, Tyree spit, he didn't cuss, he didn't do any of those things. Officer Mills was there, he told you. Officer Hemphill, the guy from the first scene. None of that. Officer Hemphill described him as polite. Help me. Who was going to help him? When he's laying on the ground right there, when you hear him say, help me, resisting or surviving, trying to survive.
Trying to survive.
Y'all hear that first kick that we called the soccer kick? You can hear it make contact in that video. You can hear that kick. Resisting or surviving. I'm going to take y'all back to last week when we were still in Chattanooga, shift gears. Y'all remember during jury selection we talked so much. There was the Rock City stoning, remember that? And there was a robbery. I talked a little bit about the movie Ocean's 11. Everybody remember that? We were talking about criminal responsibility. And the judge has given you the law now. It's page 58 of your jury instructions. If you want, you can follow along. I'll put it on the screen. As we talked about last week, there's 2 different ways, page 58, 2 different ways you can be criminally responsible for the conduct of another. And both of these apply in this case. And we're going to find those 2 different ways in the 2nd and 3rd paragraphs of page 58. So, what criminal responsibility is, and I think y'all got it from the examples, but now we're talking about this case, right? Last week we were talking about examples of bank robberies and the Rock City stoning. Now we're talking about this case. 5 officers out there. 5 officers acting together. The 2 different ways that you could be criminally responsible for the behavior of another. The first way is in paragraph 2. The defendant is criminally responsible for an offense committed by conduct of another.
Hi, I'm Dustin, and this is Nathan with Drive Fast USA, Omaha's new Buy Here, Pay Here headquarters. Bad credit doesn't matter.
Or to benefit in the proceeds or results. The defendant, here we go, these are the things. Solicits, directs, aids, or attempts to aid another person to commit the offense. We're not going to focus on directs. I think that'll come up in our proof. You'll hear more about that evidence as I go on. Aids, attempts to aid. So that's one way you can be criminally responsible. Another one, and a huge one in this case, is found in paragraph 3. The defendant is criminally responsible for an offense committed by the conduct of another if, having a duty imposed by law, and here that's what we're functioning under, imposed by law, to prevent commission of the offense and acting with the intent to benefit in the proceeds or results of the offense, or to promote or assist its commission, a defendant fails to make a reasonable effort to prevent commission of the offense. Okay? Aids, attempts to aid, or duty to prevent.
Duty to
So
prevent.
as you go through,
Ooh,
you get back to the jury room, and you go through
they in
these
trouble.
deliberations,
All of them.
and you're considering the conduct of these individuals, you have to consider it
Because they didn't
under
tell
the
it.
umbrella of criminal responsibility.
They didn't report it. They
And
lied.
if you read the jury instructions, and if it says the defendant, it's the defendant or one for whom he is criminally responsible. Okay? I'm going to point that out before I go further. And the other thing I want to look at quickly is page 4. And that is the instruction the judge just gave you. And this is page 4. If you want to look, we'll put it up on the overhead as well. This is second-degree murder. Second-degree murder only has 2 elements. That's what's listed as 1 and 2. Defendant unlawfully killed the alleged victim, Tyre Nichols. 2, the defendant acted knowingly. 2 elements for the state of proof. And we talked about this with y'all last week. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. Reasonably certain to cause the death of the alleged victim. Another thing I want to point out is after it defines knowingly, it says the requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally. Knowingly or intentionally. What I want you to think about as we continue to discuss the evidence today is how do you know what somebody knew or what they intended according to this? You know based on their actions and their words. That's how you know someone's intention, right? What did they do? And in this case, you can see. You can see what they did, and you can see what they didn't do. You can also hear what they said. So keep those things in mind as we discuss the evidence today. Keep those things in mind as you go back in that jury room and have all this evidence. And you can rewatch any portion today during, I'm sure everyone's closing arguments. If somebody points to something that happens, make a note of that timestamp, because you will be able, if you want, when y'all go back to deliberate, if there's any questions, y'all can watch all these videos and find these things for yourselves, okay? So speaking of video, I'm about to play another one, but I want to kind of talk a little bit about what we're going to look for. I'm going to think back to Mills' testimony. Mills, bigger, bald guy, testified. You see him on the video. He's the guy with the baton, right? He's also the guy with pepper spray. Pepper sprays first, then batons. Why? Why did he baton it? Do you remember what he said? He was angry. He was angry because he just sprayed himself in the face. And we heard from many use of force experts, 3, right? Each defendant called 1. And one thing they all agree on is if you're using force out of anger or to punch, that's excessive. And Officer Mills sat here and told you that's why he got his baton out, because he was angry. He was angry. The first video we're going to watch is going to be the pole cam. And that's sort of the eye in the sky, right? The pole cam video. And this is going to be a little zoomed in. I'm going to slow it down a little bit. And the reason I want to do that is so we can focus on the actions of officers Bean and Smith. Keep in mind, criminal responsibility. Aid, attempt to aid, duty to prevent. They're aiding. In the beginning of the video, remember how it all sets up. Bean runs in, tackles him, Smith gets there right after, and there's stuff going on the ground in the very beginning. And then the next thing we see is Officer Mills, and then Officer Martin. So there's 4 officers and Tyre. I want you to focus, watching it this time. You see a lot of the same video, but I want you to focus on different things when you watch it. On this time, I want you to focus on Bean and Smith. Okay? Now we all remember Smith is the one who has on tennis shoes, right? And they have a white sole. So it's easy to spot him. And at different times he has on a baseball cap. Bean has on, a sort of a head covering, and you'll see him. So they're the 2, and they're holding Tyre down. I want you to look at where their faces are, where their hands are, especially when Emmett Martin comes in with that first soccer kick, then with the second. Then the punches, they're on either side of Tyre, holding his arms while he's getting punched. And Emmett Martin's doing the punching, and he describes those punches as haymakers. And do you remember Mills being asked, what's a haymaker? And he said it's a knockout punch. Like one punch to do it. And we know from the video that Tyre gets at least 5 of those from Emmett Martin, while Bean and Smith are holding arms. Then, the next thing we see, Tyre's back on the ground. Bean and Smith are still holding down. And that's when we get Haley run in, get his kick in. As he says, beat that man's ass. Swift kick. And then Martin gets another kick. All right? So think about what you see Bean and Smith doing in this version of the video. Just to make sure, Emmett Martin's on the front of the screen closest to us. Again, you know who Justin Smith is because he's got the shoes on that are easy to spot. Bean's the other guy right now holding Tyre.
AunTeaFee. Okay. Yeah.
Y'all keep an eye on the Bean and Smith and that, where their faces were, what they're looking at, what they're doing. We see those first two kicks. After that first kick to the head, you heard all use of force experts agree and testify that first kick, that soccer kick to the head, is what? Excessive force. Unnecessary. Deadly. And after that first kick, what do we also have triggered? The duty to prevent. The duty to prevent. Criminal responsibility. Duty to prevent. Bean and Smith holding him down. I mean, their faces are right there. And that first kick, you can hear it on the video. Can you imagine? If you were holding the person that took that impact, you would be able to feel it. We can hear it. But they're holding him, Bean and Smith. So, first kick, right there. Duty to prevent. Duty to intervene. Second kick. Duty to prevent. Duty to intervene. Then those punches come, they're holding it. I mean, I know you've got all the baton strikes, but we're just putting that in another bag. They're holding him. And that's when the haymakers come. And you can see them. You just saw them. Yo, watch it, count them out. I count at least 5. And you can watch how hard they are, because watch what happens to Tyre's life, his head, how it's impacted by these punches. And after each one of those punches, what do we have? The duty to prevent, the duty to intervene. But these guys continue to hold. Then he's down on the ground. So now we're 2 kicks, at least 5 punches in. That's 7 times. 7 times. Those guys intervened, could have prevented, could have done something. Could have just said stop. Nobody said stop. And after those 2 kicks and after those 5 punches, they're on top of Tyre. Because there's a little minute there where you see, you know, they're just sort of in a pile on the ground. Tyre's on the bottom. Bean and Smith are there. Martin's kind of standing over him for a minute. And it's at those moments where in the first video we heard Tyre say 3 times, "Help me." And what's the next thing that happens? Officer Haley. Beat that man's ass, he says.
And they went back in.
Responsibility directs. AIDS attempts to AIDS directs. Beat that man's ass. Runs in, kicks. Again. Bean and Smith right there where the kick took place. Triggers again what? Duty to prevent, duty to intervene. Nobody does anything. And then after Haley says beat that man's ass, does his kick, then we get Martin back in with another kick. So that's a total of 9 times. 2 kicks in the beginning, at least 5 punches, 2 kicks in the end. Not one person does one thing. Not even so much as say, stop, hey, whoa, don't you think that's a little much? Nothing. Nothing. So then the defense is going to tell you they pepper sprayed, they didn't see anything. But keep in mind, we can hear these impacts from somebody that's on the ground somewhere over there we don't even know. And these men are physically holding Tyre's body while this is happening, with their faces this close. They're going to say they couldn't see it. They were pepper sprayed. They had tunnel vision. There's just no way. We got 9 chances. Watch them. What I'm about to play is Mills' body worn camera. And again, you've seen this but I want you to watch it with fresh eyes. And what I want you to focus on is the reaction. First of all, Mills, before he sprays, is trying to be responsible about it, right? He's like, hey, y'all, watch out, watch out, watch out. You'll hear him say that. Like, I'm about to spray, watch out. Meaning, get back so you don't get sprayed, right? And you will see, the first time he says that, Bean and Smith step back. Completely let go of Tyre and step back when he gets ready to spray. Okay? We're going to watch it in just a second. Then he sprays. I don't know where that spray goes. I don't know. I mean, you watch it, you see it, you know. He kind of steps out, he comes back in, and he says again, watch it, I'm about to spray. And this time, he sprays himself. And Martin's on the same side as Mills. And they both get it. And the defense is going to have you believe, well, it's in the air, everybody's affected. Well, let me tell you who's affected. You'll hear immediately Mills and Martin, oh, shit, you know, reacting. You'll see.
Can y'all, I'm going to pause so y'all can get my likes up. Thank you.
You know this too. You've seen those bad Bob videos that they play for a number of people. When they spray that spray in the bad Bob video, is it some huge spray, or is it a stream that goes directly into that person's eye? Think about it. You're going to have all these bad Bob videos, but that's how it sprays, right? So it sprays in a direct stream. So when I watch it, and you see Mills say, I sprayed myself, and you'll see him continue to react. He has to continue to walk off. You'll hear him. He sprayed himself. Martin was standing next to him. He got hit by some of it. You see Martin walk off. And this gets back to the point, what did Mills tell you? He's angry. After he sprayed himself, he comes back with that baton. Right after that pepper spray, when it hits Martin, he's angry. What's he come back and do? Start to kick one, kick two, punches. So, watch Mills' body cam with me and think about what you see Bean and Smith doing, how you see Mills and Martin react to this spray.
For those of us with service animals, preparation is key. Ensure your buddy always...
Oh shit, and you see Martin has to step away. You can also see right here, that's Martin. You see that little black square? That's Martin throwing down his body-worn camera. Because now Martin's pissed. So this is him throwing down the body-worn camera. That's 20:33:51, about there. If you don't want to look at it when you get back there. Here's Martin throwing down his body-worn camera because it's on. You immediately see Martin and Mills react to that spray. They get angry, and then we'll watch what they do next. Yelling commands at Tyre. And this is when he's kicking him. And this is why Mills testifies he didn't see those kicks, because he's over here in the back of his car dealing with his pepper spray when those first kicks happen. And again, when you have the body cam back there, you can line all this up. Testified, and y'all couldn't hear a word he said almost because he was the softest talker you've ever heard in your life. Listen to how angry. Listen to the scene. I'm about to baton the fuck out of you. You can hear that. You can hear anything he said on the stand. You can hear that. Because he's angry. They're angry. Keep in mind, Dean and Smith, where they are, what they're doing, how they're assisting, how they're aiding, as they're holding those hands while Martin is delivering these haymakers, how close they are to Tyre, how close they are to Martin as this is happening. And you notice, you see in Mills' body cam capture some of those punches, and if you'll remember, Mills told you he heard the first thump, he called it. He heard the first thump, and then he looked and saw what was happening, and he turned away and walked off. Duty to prevent, duty to stop, he didn't do it. He told you. But he saw it and he heard it, and he said, I knew it wasn't good, and I walked away. And that's what we see him do. He just walked away.
We are east of the intersection.
and Smith, when those first two kids happened? His answer, right there. Where were Bean and Smith when Martin was giving those haymakers? Right there. Right there. Mills told you he didn't do anything to stop it. He didn't tell the EMTs or paramedics what happened. He regretted it. And he played good.
He did say that.
And that's Mills.
Not them three.
So we talked a lot and looked at what Bean and Smith were doing. And in many respects, you can kind of put them in the same category.
No
Because
remorse.
they're doing the same things. Haley, a little different. And we brought it up, we talked a little bit about it. But Haley is different. His attorney has brought it up on every possible occasion. Well, Haley didn't have a duty to prevent these things. He didn't say, well, of course, I agree with that. You can't report something you never saw. Of course, I agree with that. So let's talk about what Haley did do and what Haley did see. And we just got a little clip of it at the end of that. What do we know about Haley? Back to the pepper spray, right? Remember the video from the first scene? Haley tries to pepper spray Tyre and sprays himself. And you see, remember that video from the first stop where Hempel's holding Haley, watch his eyes out, and he stays there on that first scene. That's why he's not here already, because he's there watching his eyes out, right? That's happening at the same time. But once he feels like he can drive, he gets in the car and drives to this scene. And comes running in. Running. Not assessing, not taking his time, not saying, hey Dean, hey Smith, Mills, what's the situation? Where are we? But see, cuz, where are we? What's happening? Runs in.
Oh, my battery.
Says, beat that man's ass, and does a kick. And as soon as he gets done with his kick, Martin comes back in and gives another kick. We heard from 3 use of force experts. And they, all 3, agree that every use of force that Martin did was excessive and unnecessary. 2 of them, Tisdale and Zawicki, said Haley's kill. And unnecessary. One said Haley's kick was fine. And that was Mr. Cameron, who is Haley's use of force expert. He says that Haley came in, made an assessment of the scene, surveyed Tyre Nichols, and decided to deliver a kick expertly to the certain area that would allow them to then cuff Mr. Nichols.
But he didn't cuff him.
Maybe Mr. Cameron has some x-ray vision. I don't know. Y'all have the same video that Mr. Cameron had? You watch it. You decide if that's what Haley did. As he said, beat that man's ass. And then kicked. He also wanted you to believe that that was, again, the verbal judo. Beat that man's ass. So, I'll leave it to you. If you agree with Mr. Cameron that Haley's tick is fine, there's another kick right after this.
Another one.
Which triggers what? Duty to intervene. Duty to prevent. Stop. Nobody so much as says the word stop one time. But then, what does Haley do? After they drag Tyre over and prop him up against the car, what does Haley do? Takes a picture. A little trophy pic. Well, let's watch just a little video. I know y'all are worn out, you'll see it at a time. We'll watch this video, and again, we're looking at the actions of Haley. What's Haley doing in this video? What does he say? What does he do?
He didn't do his job.
And this is going to be the sync video. This has the poll cam video, but the audio you'll hear is from Officer Bean's body cam. Dean, Smith, Martin, all there. Taking 2 kicks, 5 haymakers to the head. And you'll hear sort of the beep. It sounds like a car locking. And right after that, we're going to see Haley running into the scene. What does Haley say right after he delivers that kick, after Martin's kick? That motherfucker made me spray myself. Because he's pissed. He's angry. And he is reacting out of anger. Runs in, delivers that kick. Dean and Smith right there. Duty to prevent. Then, after they drag Tyre up, prop him against the car, and start high-fiving, fist bumping,
Yep.
talking about who got the best licks, who did what. Haley walks over and takes a picture.
Trophy.
Mr. Nichols?
To send to the mob.
Did his
Collect on
expert
that.
testify he was documenting
that body.
injuries? For what? For who?
For God.
11 people he sent that picture to? Pull that picture up. So after yelling, beat that man's ass, running and kicking, hanging out, high-fiving, talking, he goes over and takes this picture and then sends it out to at least 11 people, was the testimony we heard. And what about the text thread he had with some other MPD officer Fox, or so it was saved in the phone?
What did it say?
Whoever MPD Fox is must have heard about the incident. Who beat dude up last night?
MD5.
Haley responds, us? They relieved some folks for real? Yeah, 6 of us. Damn, I don't understand why though. I guess it's just procedure, I don't know. Shit's stupid. Keep y'all head up, Brody. The city need y'all for real, for real. Appreciate it, bro. No big deal. Who beat that man up? So when you start to think about what Haley's intentions were, if Haley did things knowingly,
Yeah, I know what I thought of when I hear
his
Fox.
words, you can look at his text to know what he was thinking. What he was doing was intentional in knowing. Look at his picture. Look at his text.
What just happened?
say the state of Tennessee versus Tadarius Bean, Justin Smith, Demetrius Haley, Emmett Martin, and Desmond Minutes. You know who's not on trial this week? Tyre Nichols. He's the victim in this case. And by the time y'all hear from the defense today, they're going to try to have you convinced that Tyre should be on trial. They're going to show you these credit cards that were found in his car. Days after. These officers had no idea those cards were in that car.
And they don't know how they got in there.
Talk about some mushrooms that were found in the trunk of Tyre's car. 1.77 grams. Do you remember TBI agent Chuck Baker who testified? He was asked how much is 1.77 grams, and he said a dollar bill weighs about a gram. So the amount of mushrooms that were in Tyre's trunk were the weight of $2 bills. And so because of that, he deserved this? Because he had those credit cards in his car? They didn't even know. They didn't even know that stuff was there. TBI found that when they executed a search warrant on Tyre's car days after the event. But they're going to say, well, he was guilty of something, so that's why he was running. So let's just take a minute and think why Tyre was running. And this is where it gets tricky. Because you got to put a lot of faith in what Emmett Martin says. Hill told you that he was out there and he heard Martin say that he had one speeding. Hemphill didn't see anybody speeding. Do you remember what he said he saw Tyre Nichols do? Improper lane change, meaning he went in the other lane without turning his blinker on. And if Hemphill had had to arrest Tyre Nichols that night, the violation he saw was improper lane change. And flee, he says. If you remember that video, it was Martin's body cam. Those blue lights are on for maybe 20 or 30 seconds. Keep in mind, these are unmarked cars. It doesn't say Memphis Police on the side, right? They're just Dodge Chargers, no markings. They do have blue lights. So he has blue lights on for like 30 seconds.
Looking for custom glass and mirrors? Look no further than the Hayes Company, Kansas City's source for custom glass.
Driving like a crazy person and trying to get away from them. Why then? Do you remember where they see him? At a red light. With his blinker on, waiting to turn to go into his neighborhood. He's sitting at a red light with his blinker on, waiting to turn. This is when they encountered Tyre for the first time. And we're going to play just a clip from that scene. It's that chaotic traffic stop where they're all given commands. It's chaos. I mean, y'all remember that game Simon Says? Like, and then you had to do it in the order? I mean, this is like the deadliest, craziest game of Simon Says I've ever seen. They're lay flat, do this, I'll break your arm, give me your hands, do this. I mean, it's total chaos. And think about this too. As the other scene, after the fact, once Tyre high-fiving and talking about what happened at this stop. One of the things, Tyre Nichols doesn't have a shot. He doesn't have a chance. They drag him out of the car.
Yeah, I was out of juice and I wasn't gonna, hey y'all, hey Willie, hey Sheila. They didn't get the lights up. I'm trying to charge it, and because I'm not gonna hold it, and they not support my platform. So we just let them lead. He was trying to go home. He was confused as hell about what was going on. And why was they doing this? For what? What's going on? Y'all doing too much. What? For a blinker?
Why is Tyre running?
Scared.
I submit to you, it doesn't have anything to do with these cards or mushrooms in the trunk. I submit to you, he's running from those officers. And then the defense is also going to make a big deal about that pole cam where you can see Tyre kind of hiding behind the cars. Yeah, he is. He's hiding from them. And they're going to say he's hiding things, putting things down. You watch the video. It's not there. Chuck Baker, the TBI agent, told you there's nothing there. He's not hiding anything. There's nothing there. You watch it. He's hiding from those guys. Y'all stay with me. I know it's late. I've been talking a long time. I know you're hungry. You want lunch. I got a little more to go, and then we get your lunch break. It's also not the state of Tennessee versus Robert Long. Remember the little EMT who sat up here and testified? They want to say, well, he should have done this, and he should have done that, and he should have done this. Well, they're the reason he's there.
Facts.
If they hadn't done what they did, the EMT would never have had to respond. He responds, and he thinks he's responded to a pepper spray and tasing. Remember that first interaction at the first scene where he talks to him, Phil? He said, no, it's not for me, because they were real confused. They were like,
Right.
you called
And they
us
said,
in.
go down to the
He's
other.
like, no, it's, And they say, the patient, where's the patient? And he's at another location.
From Tina Fey and the creator of Saturday Night Live comes Mean Girls, the hilarious hit Broadway.
But that's what they were responding to. And then they get there and they see what Tyre looks like. And he told you, I assume, because he ran, when they tackled him, that's how he got the injuries that I could see on his face. Nobody told him. Nobody told him what really happened. So don't let the defense blame shit. It's not EMT Long's fault. It's not Tyre Nichols' fault that they did what they did, because he had some credit cards in his car, because he had 1.77 grams of mushrooms. We hear about the acts of these defendants. That's who's on trial this week. All right, if y'all stay with me, we got to look at the law for just a second, and I'm going to go through it fast. One thing before I do, the medical examiner, Dr. Ross. And you'll have his report, that's part of evidence when you go back there. The main thing that caused, the ultimate cause of death was blunt force injuries to the head. Based on the video that y'all have seen 1,000 times now, that doesn't surprise me. But what I want to draw your attention to, if you'll remember when he testified, he talked about torsional injuries. That's the thing about torque, right? And he described how your skull, your brain is inside the skull and it's attached. And if your head is hit with so much force that the brain can't keep up with the skull and it tears away. And those torsional injuries are what Tyre Nichols had. That's what caused the brain trauma. And how, as Dr. Ross, when do you normally see that? Do you remember what he said in car wrecks? That's the kind of force we're talking about. But what's the other thing that makes that significant? In a car wreck, seatbelt. You're being held in position, and the force makes your head turn while the rest of your body doesn't turn with it. And what do we know about what was happening out there that night? Bean and Smith are holding Tyre down when those first kicks come, so his body's being held stationary while that force goes to his head. The force of the first kick, the force of the second kick. And same thing when we have those haymakers, those punches. Again, he's being held. Normally, if you got punched with one of those, you just fall down. Your body would go with the force of the punch. But if you're being held, you can't. So look at that report. All right. The instructions, I'm not going to read them all to you. I'm going to go through a few things. I got a few pages I'm going to talk about, and then I'm going to sit down. I promise you y'all can eat lunch. So stay with me. First one I want to talk about. I'm just going to talk about, there's 7 counts of the indictment. Going to look at that. There are a bazillion lesser included offenses. You don't notice that when you touch this reading. I submit to you, you don't need them all, because the state's proven the charges in the indictment. And if you agree with that, you don't need to look at the lesson, because we just go with the counting the indictment. The first one, second-degree murder. We've talked about this. This is page 4. And remember, when we think about all this, we have to think about that sort of umbrella of criminal responsibility. So every time you see defendant, that means any of these defendants or anyone for whom they are criminally responsible. Okay? So second-degree murder just has 2 things. Defendant unlawfully killed the alleged victim, Tyre Nichols. Defendant acted knowingly. I submit to you based on the proof in the medical examiner, the brain trauma, those injuries were caused by haymakers to the head. That the defendant, Emmett Martin, or criminally responsible for his behavior, right? They're all out there. We're all doing it together. Certain people are holding, certain people are kicking, certain people are taunting. We got all sorts of things going on, but they're all engaged together. Aid, attempts to aid, or duty to prevent. That's second-degree murder. That's page 4. The next one, page 15, is the second count of the indictment. Aggravated assault acting in concert. This has 3 elements. The defendant intentionally or knowingly caused bodily injury to Tyre Nichols. Check. The act resulted in serious bodily injury to Tyre Nichols. Check. Right. 3, that the defendant committed the offense while acting in concert with 2 or more other persons. Check. Right. So a total of 5 officers involved in this. 5 officers listed in the indictment. We have 3 on trial this week, but you've seen what Emmett Martin's doing out there, and you've heard from Officer Mills. The next count of the indictment, count 3, is on page 23. If y'all want to turn to it, we'll put it up. And the next 2 counts are the same, so we can kind of cover them at the same time. It's aggravated kidnapping. And this, probably all the counts, sounds the weirdest at first. You think about kidnapping, you know, somebody grabs somebody and ties them up and puts them in the trunk of a car and drives across town and dumps them out. Clearly that's not what we have here. So this is a sort of a different way to think about kidnapping. So look at the elements of aggravated kidnapping here. And so this is count 3, it's aggravated kidnapping with bodily injury, and count 4 is going to look just the same, except it's an alternate theory, and it's aggravated kidnapping while you possess a weapon, okay? So we can kind of look at these at the same time. That the defendant knowingly removed or confined Tyre Nichols unlawfully so as to interfere substantially with his liberty. So the state isn't arguing that he was removed, right? It's that he's confined, that he's cuffed. And he's propped up against that car. Unlawful. There was a time that night. There was a time when those officers could have arrested Tyre. That would have been lawful. But that changed the minute we got that first soccer kick. That first use of excessive force that no one does anything about. That's when it changes. It's when, from that moment forward, everything that they do next is unlawful. So when he's sitting in cuffs, propped up, his liberty is clearly interfered with. He's propped up against that car, and they're high-fiving, hanging out. Nobody's rendering any aid. You heard the use of force experts that officers have a duty to render basic medical aid that they can't. Nobody's doing anything. Really not even paying attention to them at all. EMTs get there, nobody tells anything that's going on. So that's the kidnapping. It's when he's there cuffed, liberty interfered with, he's confined, and we know he has bodily injury. During that time, he's basically dying. We know by the time the paramedic gets there, he's going into cardiac arrest. And shortly thereafter, you heard Dr. Ross talk about all the things that are happening to his body and how quickly that's happening. And then he goes into organ failure. By the time he gets to the hospital. So 23 is aggravated kidnapping with bodily injury. And page 32 is aggravated kidnapping with a deadly weapon. And again,
Oh, wow.
the only difference you'll see here on page
Hold on, y'all.
42 is
You have to
under
hold it
number
up.
2 is that the defendant possessed or threatened the use of deadly force. I'm sorry, the use of a deadly weapon. Possess. All these officers have a gun. They possess a deadly weapon while they have him restrained unlawfully, while they have him confined and are interfering with his liberty. So those are the two theories of aggravated kidnapping. One with bodily injury, one with weapon. That takes us to official misconduct, count 5. And this is page 37. If anybody's following along, we'll put it up on the screen as well. And at the top, you'll see official misconduct, unauthorized exercise of official power. Count 6 is another count of official misconduct with a different theory. We'll look at it next. Unauthorized exercise of official power. This one has 4 elements. You'll see them numbered. Defendant acted as a public servant. We know these are MPD officers. Their oaths of office are part of the evidence you all will have. Number 2, committed an act relating to the defendant's office or employment that constituted an unauthorized exercise of official power. So from the moment of that first soccer kick, everything going on out there is unlawful, and now it's unauthorized use of their official powers. Because we've had excessive force and nobody's stopping it. Number 3, that the defendant, and remember this is the defendant's plural, or the defendant, one who is, criminally responsible for, right? So, and then 4, the defendant acted with the intent to obtain a benefit or to harm another. Clearly, Tyre is harmed. So that's the first count of official misconduct. The second count of official misconduct is on page 41. And this is an alternate theory. This is refraining from performing a duty. So it's all the same elements 1, 2, 3, 4 that we just discussed, except number 2 is the difference. That the defendant refrained from performing a duty that was imposed by law or that was clearly inherent in the nature of the office or employment. Refraining from performing a duty. This guy had a duty to inform the EMT about what was going on, about what they had done, about what kind of care the staff needed. Nobody did anything. And that takes us to the last count, count 7, page 44.
7 counts.
And this is official oppression. It has 2 elements. That the defendant was a public servant acting under color of office or employment. Yes, these are MPD officers in uniform. That the defendant intentionally subjected another to mistreatment or to arrest, detention, stop, frisk, halt, search, seizure, or dispossession that the defendant knew was unlawful. I'm going to go with mistreatment. Tyre was subjected to mistreatment. I promise I'm almost done. The last one we're going to look at is kind of where we started. Page 58, criminal responsibility. different ways you can be criminally responsible for the conduct of another. Direct, aid, attempt to aid, focus on those. Duties to prevent. Commission of the offense. Okay? Do you remember this week when we watched sort of a little animated video? Lieutenant Smith put it on, and it was like a cartoon thing where it only showed what Smith was doing. Remember that video?
Mm-hmm.
That's not what happened out there. It's 5 officers acting together. If it was one officer out there, would we be here?
A police gang.
No.
A whole
If it was
police
just
gang.
Justin Smith in that animated video, no. That's not real life. That's an animated video. It's a vacuum. Every step of the way, you'll see all these videos. What do you see? You see these officers working together. Holding arm, while he's getting punched. Holding down, while he's getting soccer kicked. At the end, after he's on the ground, 3 officers on top of him. That's when we got Haley rolling. Beat that man's ass, kick, another kick. All 5 officers. Not one. All 5. But it's not just their actions that you have to look at. You also have to look at their omissions. The duty after every one of those impacts, and I count 9. 2 kicks, 5 haymakers, 2 more kicks, 4 total kicks, 5 total punches. Every one of those requires a duty to prevent, a duty to intervene. And that's part of criminal responsibility. And not once did someone so much as say, stop. In fact, as soon as it's over, we start fist bumping, we start high-fiving, we start playing back what we all did. It was so great. Ladies and gentlemen, in our opening, Mr. Hagman told you these men aren't monsters. We're not here to tell you they are. You've heard from a bunch of character witnesses for Bean and Smith. So they're great guys, good officers. Okay. What we're here to talk about is what happened on January 7, 2023. And not one of those character witnesses was on the scene that night. I told you last week, it came up when we were still in Chattanooga. Something about the jury voting good or bad. That's not what you go back there to do. Not good or bad, not right or wrong. But did the state carry their burden in proving these 7 counts? Did they prove that these 3 officers did what we say they did on January 7, 2023? Are good people capable of doing bad things? That night, January 7th, 2023, those 3 officers did bad things. And when Tyre cried for help, nobody helped. Nobody prevented. Thank you.
All right, ladies and gentlemen, we are going to go ahead and take a break at this time, allow you all to have your lunch. We will call you all back.
Okay, y'all, I'll be back.
Started again. We'll then go ahead and choose a jury.